Nice to see you too.
Greetings. I'm Sam Blakesley, and I'm a co-proponent for the California Legislative Transparency Act, which will appear this November. And I must respectfully oppose the SCA as it's drafted. As you know, I've had the distinct privilege and honor of serving in both the Assembly and the Senate for almost a decade, including a stint as a minority leader. So I approach these issues from a perspective of deep personal commitment, and also not as someone who's doe-eyed, misunderstanding the complexities of how the legislature can and should work, but someone who wants to effectively help the legislature move forward in an arena that I think everyone that we've heard speak today agrees needs attention. So why am I so thrilled to be here? Because we're not just talking about any bill. We're talking about a bill that will reform the conduct of this legislature. And we're talking about a legislature that has a distinct role of voicing the hopes, the dreams, aspirations, the values, and more importantly, the will of the people, which is why it's so important that we do our work in the public's eye. Earlier this year, bills were drafted to put a stop to special meetings with the California Coastal Commission members. And last year, the legislature sprang into action when members and staff of the California Public Utilities Commission were found to be operating improperly behind closed doors. Indeed, over the years, the legislature has passed numerous laws designed to end dealings that exclude the public and to bring sunlight to the operation of government. For example, and those of you who've served either in local government or in state agencies will know this well, this legislature passed the Ralph Brown Act of 1953, the Bagley-Keene Act of 1967, the California Public Records Act of 1968, and the California Sunshine Act of 2004. And all of these measures had three things in common. First, each forced greater transparency onto government despite the objections of those public officials who would be covered by these laws. Second, each was written by the legislature to protect the rights of the public. And third, each was intentionally written to not apply to this institution, the legislature. And I'm not the first to cite these facts, as virtually every major newspaper has decried this body's aversion to applying the same rules to itself that it applies to others. Indeed, over the years, legislators have authored nearly 10 different measures to require a bill to be in print for 72 hours before it could be voted on. Many of these proposals were defeated without being given even the courtesy of a hearing, let alone a vote, and none has ever passed out of a policy committee, let alone off the Senate and Assembly floor. And now, after years of work and filing 1 million signatures with the Secretary of State, a citizens' initiative is moving its way to the ballot so that voters can have the opportunity to do what this legislature has refused to do. And now at this 11th hour, the legislature has written a competing measure to the citizens' initiative, and it is designed to go on the exact same ballot. And here we are, testifying on this measure, and as the good senator mentioned, we are in an era of SB 1253 where coordination and cooperation was envisioned. But let me just point out that part of that process was an SB 1253 hearing to start the dialogue, which was supposed to commence not 3 weeks before the deadline, but when the 25% threshold was met. We met that threshold months ago. We have yet to be invited to a SB 1253 hearing. So it's important to put that in context because we have worked for a very long time on this language, and we are now facing a very short time frame to respond to the legislature's involvement and interest, newfound interest in this issue. I will tell you that we would cheer the legislature's late effort if the measure were complementary to the citizens' initiative by addressing additional important issues. And we know there are many from which to choose. For example, SCA 14 could have been a constitutional amendment providing improved budget transparency, an area which CalPIRG gave this state an F rating. We would have certainly cheered that effort and be here in strong support if that were the transparency measure that was being contemplated. Similarly, we would cheer the effort if the measure was designed to strengthen the citizens' initiative by going further in providing greater transparency, for example, in the conduct of how committees operate. But unfortunately, the measure before you today neither complements nor strengthens the citizens' initiative. Instead, it is a measure rife with loopholes designed to weaken the reforms already headed to the voters. Therefore, I must sadly and respectfully oppose SCA 14 as written, and hope that it will either be held or an active effort at amending these problems will be addressed in the near future. Thank you. And with that, I'd like to introduce Dr. Charles Munger, Jr. With further comments.
Thank you, Senator. Mr. Munger.
Thank you, Mr. Chair. Thank you, Mr. Chairman, honorable members. As Senator Blakesley has mentioned, he and I are the proponents of the California Legislature Transparency Act, or the CLTA, an initiative state constitutional amendment and statute. Qualification of CLTA for the November ballot is certain. Partial list of our endorsers for this measure: the League of Women Voters of California, the California State Conference of the NAACP, the California Black Chamber of Commerce, the National Federation of Independent Business, California, the Los Angeles Chamber of Commerce, the Howard Jarvis Taxpayer Association, California Common Cause, Californians Aware, the First Amendment Coalition, California Forward, the California Chamber of Commerce, the California Business Roundtable, La Raza Roundtable de California, the Small Business Action Committee, the Fresno Chamber of Commerce, the San Jose Silicon Valley NAACP, the Hispanic 100. These groups don't come together on much, but they have all endorsed the CLTA. The question before this committee, therefore, is not the usual one, namely whether SCA 14 and its companion AB 884 together, if approved by the voters, would improve the transparency of the legislature. The question instead is whether these bills would improve it more than would the CLTA. And the answer, as amended, is no. And surely we can agree there is no point in this committee moving to put on the ballot and to ask voters to adopt an alternative inferior to one on the ballot already, particularly when the CLTA has proven broad support outside the Capitol Dome and the inferior alternative does not have it. Now, as initiative proponents, we have faithfully engaged with the legislature. SCA 14 indeed was originally submitted as a word-for-word copy of the 72-hour notice provisions of the CLTA, which is why even the titles of the two measures are the same. We now respectfully direct that SCA 14's title now be changed, lest the public become confused between our initiative and this bill. But the amendments of June 1 have moved SCA 14 backward, not forward. So why is SCA 14 as amended June 1 worse than CLTA? As many people have noticed, SCA 14 would require 72 hours notice only before the second House to act on a bill could pass it, not the first. The CLTA and the original SCA 14 before the June 1st amendments, in contrast, always give 72 hours notice of the text of a bill to all the members of the Assembly and the Senate and to the public before a bill can be passed in either house. Now, for a citizen to be allowed to read a bill and communicate with only one of his or her two representatives, because we have a bicameral legislature, assembly member or senator, before a bill leaves a house, and for only one of those representatives to be able, with 72 hours to read and think about a bill, to participate in the cycle of debate and amendment in his or her house, that makes no sense at all. The time taken in the legislature to pass a bill is not an issue. The same 72 hours elapses for a bill to be amended and sent to the governor's desk under the terms of either the amended SCA 14 or the CLTA. SCA 14 sets no penalty if its 72-hour notice provision is ignored. And a law whose violation is without consequence is empty. The CLTA, in contrast, provides that if the notice provision is ignored, then despite the vote on the bill, quote, shall not become a statute, end quote. Rush a vote on a bill, it doesn't become a law. unless it is voted anew with the notice duly given. SCA 14 does not guarantee that the proceedings of the legislature's present standing committees, such as this one, will be recorded. Yes, SCA 14 would require meetings of, quote, standing committees, end quote, to be recorded. The problem is that while the term committee is already in the Constitution, the term standing committee is new, undefined, and without constitutional precedent. By abundant court precedent, in particular set by the litigation over the ill-fated Legislature Reform Act of 1983, in the absence of a constitutional definition of the distinction between what a committee of the legislature might be and what a standing committee of the legislature might be, the distinction will default to the legislature's own rules. Those rules alone define the committees and their powers according to Article 4, Section 7A of the California Constitution. So, a committee will be standing in the sense of SCA 14 only if a future Senate decides it should be. That is no protection for the public at all. The CLTA, in contrast, requires that all the public proceedings of the legislature, and therefore also the standing committees, however the legislature might choose to define the term, are to be recorded. SCA 14 does not protect the public's access to recordings of the legislature's public proceedings. The recordings may exist. They need be shown to no one. The criteria for access have been put into AB 884, a statute. And a statute passed by this legislature, this committee well knows, the next legislature could simply undo. The CLTA, in contrast, guarantees that any person, as well as the press, may view recordings at will on the internet and copy, transmit, excerpt, and use the recordings freely. And only a vote of the people, not a majority vote of the legislature, could restrict access. That a key safeguard for transparency is left to the whims of a future legislature to undo is a recurring defect in SCA 14 and AB 884. While the CLTA enshrines the public's right to transparency in the Constitution, this legislation, SCA 14, leaves many of those safeguards in statutes, again, where it can be later deleted or changed. SCA 14 does not compel the Assembly or Senate to allow a member of the press or public themselves to make an audio or visual recording of a public proceeding. In fact, it was a matter of discussion just now whether a court reporter could actually take down the words that this committee was going to hear before it. The CLTA, in contrast, does, keeping the information available to the public timely and complete, and an official state recording honest, all at no cost, I might add. Under current state law, the Assembly and Senate alone of all state and local government agencies may still legally hinder the press and public this way in finding out what's going on in their own meetings in a timely way. It is time to end that exception. I will close shortly. A more detailed comparison of SCA 14 and the CLTA has been submitted to you. SCA 14 does not improve on the CLTA, and if it doesn't, what is its point? I challenge the members of this committee to hold SCA 14 in committee, pending further amendments that will themselves be subject to public comment and to review by this committee. SCA 14 is not going to start from where it is to get somewhere better than the CLTA in one jump. As written, we oppose SCA 14, and if the this legislature wishes to put it and its companion bill on the ballot, as proponents, we will not withdraw the CLTA from the ballot. We are here to engage with our legislature, even at this very late date, to see if a common vision can be wrought into a workable piece of legislation that can be put before the public. But understand that we have worked very hard to get here. We have been waiting for a long time for a show of interest. We know how hard these things are to write, and while we're willing to engage, we're also not willing to settle for second best, simply to achieve a compromise. So with that, we will open to questions from this body.
Thank you, Dr. Munger. We have other witnesses in opposition.
Yes, Mr. Chairman, members, good afternoon. David Wolf with the Howard Jarvis Taxpayers Association in opposition to the bill. Mr. Chairman, with respect to the two aside and given the prior comments, I'm not going to elaborate further unless the committee would like with a specific question or comment. So with that, we're opposed.
Appreciate you being here. Thank you. Are there other folks who want to come and raise their opposition? Okay. With that, I'd like to turn, I think the author wants to have some responses to some of the issues that were raised, and then we can open up the floor to questions of the committee and discussion. So not the author, but the senator who is presenting the amendment.
You know, a lot of what was said I agree with. And I want to go through the specifics with respect to what's before us now. And certainly I'm not the author, but I certainly will consult with her, and I've consulted with her staff just now, as you observed me doing. But this notion of sunlight in government's operation is exactly what we're trying to do here. I think the idea of greater transparency, the idea of trying to protect the public and the like is what we're doing here. Now, we're doing it at the last minute. That's true, okay? That's just the God's honest truth. Are we? Is it something that I've been in this fight for a lot of years too? I happen to be on both sides of the fence, both in government and outside of government, with a lot of groups that you're keenly aware with and to which you've referred. And I have been fighting these very fights, and I can't disagree. The test is not how far, as I said before, how long you go down the road, if you will. The test is what's the end product. And let's examine this issue. And I don't know why there was not a 1253 hearing. I don't know. And I apologize for that. But I can just say to you that we're here now, and the question is, what's the best course of action going forward? Let's examine the points that were raised. One, the issue of both houses. I know that there's been some discussion as to whether or not that 72-hour rule applies. I personally think, and certainly as was indicated earlier, that it really, the amendments happened in the second house. But from what I gather from consulting with the various folks, that's an issue that is not very hard to correct in terms of mirroring what you're saying. Two, the idea of what the consequences are of failure to adhering to this. I'm informed that Legislative Council says that something has to be passed, that they have opined, from what I gather, that the idea of something being passed means that if it's not passed and hasn't gone through this process, it's not passed and has the same effect to which your language you've talked about with respect to your language, saying the law doesn't go into full force and effect. But that being said, to me, that's a lawyering question as to whether or not the consequences are the same or not, and that works. The third element you talked about was the definition of committees, standing committees versus other committees. And also, again, I mean, I think that's a lawyer question about the definition, whether it's limited as constitutional. I understand, and I think it's appropriate for you to be cautious in that regard, that somehow this is being drafted in a way that's trying to get around it. But I'm assured, and certainly me now on the other side of the fence will stand up if that's the case, because I don't think anybody's trying to play that game of whether something's a standing committee, informational committee, and what that looks like. The idea is to open it up, and that you've been successful in that regard. Next, the notion of access. You know, again, it's the, I think, the underlying issue here, and I think certainly Assemblymember Gordon will talk about that with respect to his issue. I don't think that there's any issue on terms of limiting the access. You didn't raise, but was raised in your letters, the issue of the funding, whether it comes within the context of Prop 140 or outside of Prop 140. And again, you know, as a practical matter, my only thought was that if it was inside Proposition 140, it would have a chilling effect on how many hearings you have. And we, in this last year and a half, have had a tremendous number of oversight hearings, and in a pretty aggressive manner that I think is the right thing to do. I think every one of them was televised but that notion, and the last thing, the idea about permission, I don't think that the chairman said you didn't have permission. The idea, I think, is more just a matter of management in terms of dealing with folks that come here. It's already all on TV anyway, so I don't think in any respect, he can answer that himself, that that's what he intended to mean. Certainly I know that's not what we intend to mean as a body. It's more just a management issue as to whether you have a court reporter here or cameras or whatever, so we know how to deal with it and the sergeants have noticed. It's just an operational issue with respect to it. So the bottom line is I have no issue with your position that you don't want to make something worse. I get that, okay? And I think that's a fair and appropriate thing, and I think your objectives are fair and appropriate. The question is, you've gone through a lot of hard work. You have been dissed pretty dramatically over the years. Fair call. I don't think anybody would say that didn't happen, right? But this conversation is a winning conversation. You're now down to very small issues in terms of the largest issue that we have been dealing with for years about changing this legislature. And I think that I'm not suggesting you to capitulate until you get what you need, but I understand the frustration of how much money you had to spend and how many signatures you had to get. I get that. That's a fair observation. But you're here. You have won. This reminds me of what I just saw, the television show where Lyndon Johnson was sitting in the Oval Office with Martin Luther King and getting the Civil Rights Act, right? And then subsequently the following year getting the Voting Rights Act. These were hard-fought fights, and there were a lot of issues before that, but these are big victories. Painful, but victories nonetheless. That's why I quoted this Kennedy issue on compromise, because however painful it is, certainly from my point of view, has been in this very fight longer than you have. Maybe not, I don't know, but I think so. I get the frustration, I get the distrust, I think it's fair. That's not the test. The test is we are lawmakers, and we are looking to make a law to put on the ballot. We're looking to do it in a fair and appropriate way, fair and appropriate end result, that's something that voters can vote on that will have the impacts on the system that we're all seeking to do. You know, there was a bill before this committee some weeks ago involving redistricting. Was that your bill or was it on redistricting? Yeah, the commission's on redistricting. I've been fighting that fight for 30 years. And I sat before this legislature and watched Common Cause get up here and support your bill. I watched you adopt something that locals could do on redistricting that my own party fought me like crazy for on redistricting, and here you did it, and this House put it out. That's progress. That's what we do. These fights are ugly often in the beginning, but that's what we do, and I would just celebrate your success. Don't put down your guard. Get the deal, but I think there's nothing that you said here, I think it's fair to say, that Senator Walk would not entertain, and if she doesn't, then stand tall. But I think the notion of saying we're going to keep this thing going is good for your initiative is good for a negotiating tactic, and I think, but it's at the end of the day, if what we produce is something that works, I think it's a fair and reasonable solution, which was the compromise that was just mentioned by the League of Women Voters that was envisioned in 1253 to try to bring people to the table to be able to create an honorable discussion, however late, between the legislative branch of government and those folks who are proponents of initiatives.
Couldn't agree more with the senator. Do we have questions from the committee? Yes, Mr. Vice Chair.
Excuse me, my voice, I've been struggling with it. You know, today we're exercising the legislature's role in examining qualified propositions and to consider whether changes to those proposed initiatives are warranted and whether we'll decide to place a competitive measure on the ballot with those changes. So I think the core of this is how does SCA 14 approve upon the California Legislative Transparency Act, CLTA, and further, what's the true purpose of those proposed changes to those measures? So far, in my observance of the testimony thus far, we keep talking about how we need to change SCA 14 to improve it to meet the standard that's already qualified for the ballot. So I would ask you, what about it is so much better or an improvement than what currently is going to be on the ballot?
Well, let me answer your questions, two parts as to part one and one part as to part two. First,
Could you repeat that again?
First, with
I'll
res-
just go along.
Just go along. First, with respect to the issue of improving upon, one of the points that was made by one of the witnesses here testifying, and it's one of the things that we grappled with Ron George and with Cruz Reynoso, the former justices of the Supreme Court, and others, was this problem that so often initiatives have problems in them. And so we wanted to create an opportunity to fix those problems, because once you collect the signatures, it becomes very difficult. And so we have a provision in that when you go out and collect your signatures, you have the right to withdraw. We have a number of days that we have in the beginning that you can make corrections. But let's talk about that. First of all, if you go to Section 4.2, Section 8 of Article 4 of the Constitution, as amended here, Section 8A2, it says that no bill may be passed 72 hours. It uses the word final form. Now, people at California Forward and others have used the word final form, and we've seen this game being played before, where if somebody goes, is final form concurrence. So you can't amend a concurrence. You do a gut and amend in House 1, you concur in the next House. Is that final form? Does that create an issue where you're going to litigate? Well, what's going to happen? That's one of those kinds of questions. So by virtue of being able to engage this discussion between the legislative branch on the one hand and the proponents on the other hand is to try to fix things that could potentially be wrong with theirs. So your point number one was, well, are we moving toward the direction there were things that were wrong with SCA 14? Well, there's actually things that certainly some people, I don't know, I haven't done the analysis myself, but could be wrong with the initiative and certainly will be litigated among the parties, and you want to avoid that. Secondly, as I expressed here, there are questions where the lawyers for the proponents of the initiative are raising issues like the word past versus consequences. Well, our Ledge Counsel tells us that the way it's written complies with exactly the objective they want to achieve. So this is not an issue about being a difference with distinction. It's a difference where parties agree to intent. It's what language do you use to get to the intent. We're not disagreeing with that by virtue of what's in SCA 14. So the notion is that A, there's not so many differences, there's just interpretations. B, there could be problems with respect to the initiative that's on the ballot. And C, the motivation is the exact motivation of what has been the Constitution of the state of California since 1879 to 1966, which was the notion of an indirect initiative, was the notion of the interrelationship once the initiatives were formed at the turn of the century to be able to have a discussion with the legislature and determine either A, to make corrections, or B, to make compromises, or C, to have the legislature put it on the ballot. For whatever the cause was, it is a legitimate and appropriate constitutional discussion, particularly as the law is, to be able to have this discussion prior to the time the printing is done for the ballot to make those determinations. And so that's what this is. That's okay. That's a good thing for the legislature.
Senator, I clearly know now why Lois isn't here today and you're presenting the bill. But
Lois knows this stuff exceedingly well. Let me tell you, she worked on this with me a lot when I was out of government.
I'm not questioning her ability. I'm just complimenting how well you present it. So now that you've gone through all that, I think the crux of my question is, how is SCA 14 an improvement on the initiative? Because through all that stuff, you gave us a lot of minutia, which is all very important minutia, I may add. But, you know, you talked about the length of time that we've been working on this issue, and yet we've seen zero progress until this moment, and only when we're trying to create a competing initiative potentially. So the whole purpose of this drill is to provide a better product. So I'm wondering, what aspects of SAA 14 are superior to what we currently have going on the ballot?
Well, I got to tell you, this is my own personal view about what constitutes superior, whether the thing has an extra kung fu grip and for the G.I. Joe toy or whatever else it might have. I think superior is a constitutional discussion between the legislative branch and proponents. I believe that the initiative process should be a measure of last resort, that where the people are frustrated with their government because their government's not acting, that there should be action taken. I think that the level of discussion and the interrelationship between the legislative branch of government and proponents of the initiative is critical, albeit late. I apologize for that, although I wasn't involved, but I'm a member of this House, I'm a member of this government, and I do not stand tall and proud about this, but we are where we are. We are in a position to have an impact. There is a value, if it's the exact same language, in my judgment, to have the legislative branch acting in coordination when somebody comes forward with a good idea and we adopt it, albeit late. So I think that has a value to it. And the last point I'll reiterate is that, and I went through the points that Dr. Munger raised, you know, at least from what I can determine by my quick notes, and certainly it requires a little bit more homework, but I don't think there really is. I mean, the difference is both houses, which I think is solvable personally, and I'll advocate for it. Again, I'm not the author, so I have no authority to say otherwise, but I'll tell you as a gentleman, I will advocate for it. I think that most of the other issues are de minimis lawyer issues that are raised that are appropriate if interpreted incorrectly, but I don't mean de minimis in the sense that they're not hard to fix because the parties are aligned together.
I would suggest to you that CLTA does provide for posting within 24 hours of the recordings.
Yeah.
And SCA 14
That's right.
has no such provision
That's right.
whatsoever. So you could collect this, you could have all this great information, but there's nowhere in SCA 14 that it provides for it to be posted. And I think that is, I think that's where SCA 14 is yet again insufficient when going to the ballot in a far lesser product for consumer protections. And I look at Californians as being the consumers and government being the product. So let me finish by asking is it your position, and I don't want you to speak for the author, but based on what you've said, is it your position that the goal really of SCA 14 is to put options on the ballot and not necessarily proceed to strive to get the best product on the ballot?
Well, let me just, the first part of what you said, let me just address that Assemblymember Gordon will raise that with respect to the 24 hours, which is important in terms of his measure in combining this. But what I think is not, I don't think it's about competition. I don't think that's a fair question that you're reading. I don't think that that's the right thing. It's not about competition. That's not the purpose. You know, I mean, if the purpose is to try to get people on this to vote for stuff and play games with elections, everybody's going to endorse this thing who's running for office. That's not going to be the question. The purpose is, in my judgment, from my own personal view, I can't speak for the author, but I'll tell you for somebody who spent a year and a half of my life and all those thousands of emails, and you can ask a lot of the people here who are testifying how all those endless meetings and conference calls we had creating the 1253, which was the the Ballot Transparency Act, was to create this exact situation, to avoid things going on the ballot and to give an opportunity for the legislature to engage. So I would argue, in my personal view, it's a replacement, and we certainly heard the points of view of both the proponents. They don't want to replace. I would just appeal to, as long as at the end of the day, they exercise good faith, negotiate with the lawyers in the legislature and the staff in the legislature to try to come up with something that achieves the same objectives that they're achieving, that they stand down and we have one measure going forward and we solve the problem for which they have been solely the catalyst for making it happen.
Well, I'd like to just finish by saying quick three things. One, there's a huge distinction between a constitutional amendment and a simple majority bill. And when you think in terms of posting within 24 hours, I would have hoped that that would have been part of the constitutional transparency, that it wouldn't be changed at a simple majority vote at a future date, willy-nilly without the public's input. Second thing is, it is, I think, fascinating to me how the initiative process has given legislators the backbone that they lacked over the last 20, 30 years through all your hard work and all the predecessors that worked hard on this issue. So I'm grateful for the initiative process that we're even having this debate, and it's lasting more than a committee. When many of the times, in just the short time I've been in the legislature, these types of measures have fallen on deaf ears that can't seem to get out of any committee to make it to the floor or even to the Appropriations Committee. And I would hope that the author would consider not allowing SCA 14 to be used as a spoiler to stop transparency on the ballot by confusing it even further. And I will say, Senator, you have been more than outspoken when you're talking in terms of how long ballots are and how many measures, and that you have time and time scolded us in a very thoughtful manner on the Senate floor about proceeding very carefully. I'd hate to see SCA 14 get on your list of just one more burdensome measure to confuse the voters. So thank you.
I don't
for
want
your
it on my list
presentation.
either, sir. But let me just say one thing, just final point, if I can, Mr. Chairman, that's okay? You got a question? And that is, let me tell you something. Senator Walk is not a spoiler. Senator Walk has been engaged in this discussion. She has been unsuccessful. The benefit of having Mr. Blakesley and Dr. Munger as advocates, I think, has been helpful in terms of moving this thing forward. I don't think there's any question about it. It's an honest answer. This is not an intention to be a spoiler. It's intention for the indirect initiative to work, often not artfully, but to work the way it's supposed to work in conjunction with having the legislature put this on the ballot.
Through the chair, I'd just like to, I like to say for the record, although I never said it, the spoiler was never used in conjunction with Senator Walk. I have a great respect
She's
for
the best.
Senator Walk. It was solely in conjunction with the legislation SCA 14 that I used the term spoiler. So I want to make sure there was no confusion there. It's not the senator.
I already texted her. You're in trouble.
All right.
After Prop 50, I'm worried.
I think Senator Hancock had a question.
Yeah, I have a question. And I just want a yes or no answer, please, from everybody. Is the difference between these two measures that one is an initiative and one is a statute?
I'll respond if I may. Both are a constitutional amendment and a statute. Ours puts more into the constitutional amendment in terms of protections that could not be undone at a later point without a vote of the people.
May I be permitted a clarification? An initiative, a statute that is written by the legislature can, of course, be changed by a majority vote of the legislature. A statute which is established by initiative requires a subsequent vote of the people to change, absent a special mechanism to the contrary. There are certain technical revisions that we allow to be changed, absent a vote of the people, but our key statutory provisions involving the availability of the recordings are guarded by requiring a vote of the people in order to abridge those rights.
Okay. So would SCA 14 be placed on the ballot as a statute,
No, is it a
as an
constitutional amendment?
initiative? So once it was an initiative, say it were enacted, how could it be changed in any way more simply than if the current initiative is on the ballot? Is there any difference that way? A two-thirds vote, a simple majority?
It's part of the Constitution. It would take another vote of the people.
Once you've amended the Constitution, you have to
No,
re-amend the
well,
Constitution
your-
again,
So
two-thirds
your
vote.
entire measure is in the Constitution?
No.
Well, that is unfortunately not in our write-up. That is why I am asking, because we haven't had the informational hearing on the initiative. So if I'm not going to be able to get a yes or no answer, let me explain where I'm coming from. I chaired this committee for 2 years. We had a big hearing on the initiative process during that period of time because there was enormous concern over the length of the ballot, over the fact that initiatives become very difficult to change if they have unintended consequences, as many of them have had, and that it was becoming increasingly apparent that qualifying an initiative was often a matter of money, and that we even had special interest bills for particular businesses put on as initiatives. So in going through all those those issues and considering solutions, we did decide that the process itself is truly worth keeping. And I've come to appreciate it even more in recent years for two reasons. I do believe it's sometimes necessary, that there are times when interest groups with a lot of sway in the Capitol will absolutely just keep something from happening. And it may not even be a major thing, but an example I will give you is the treatment of animals. If you remember Measure 4, and that was the Humane Society finally put it on after measure about whether chickens could turn around in their cages was defeated in the Agriculture Committee. And it passed, and it would not have been able to pass this legislature, I don't think. The second reason I've come to like it more is that it exactly sometimes forces action from the legislature. And I remember after bill after bill after bill had been defeated in the Judiciary Committee and the Assembly regarding privacy and bank accounts. Now Congresswoman Jackie Spears stood there with a millionaire behind her saying, if you don't pass this, we're going to have an initiative. Well, the bill passed, lo and behold. And nobody's changed that since that time that I can remember. Sometimes it's an impetus for action. That is, what I see here. Because I agree with, I think all of the things that I understand, the keeping the recordings, making them available, no cost, absolutely. 72 hours, many of us here supported Senator Wolk in this effort over time. I do think, though, that we've reached the point where our state constitution is a joke. It's kind of a collection of statute and an expression of frustration. So, unless I'm misinterpreting what's going on here, the differences in these measures may be slight or non-existent, except that one would be essentially a statute and one would be more a series of constitutional amendments. I think that's a discussion that ought to proceed, and I would come down in favor of statute just because of the lessons of history that I've learned in the last 14 years. But again, I think it's great that the authors did this. Sometimes that's what it takes. We know that.
Thank you, Senator. Okay. My thoughts are very much in line with those articulated by Senator Hertzberg. I think that ultimately there's clearly, it seems from listening to the discussion that the key sticking points that the initiative authors have we should be able to work out. I mean, I agree. Ultimately, I think what the senators are trying to do here, Senator Anderson, is avoid adding to the ballot clutter if we can figure out a mutually agreeable way of addressing the core transparency issues that are behind the CLTA proposal. And so I understand. I think that I'm going to support moving this forward with the understanding that a discussion is going to continue and hopefully intense negotiations to see what we can get, or where we can see eye to eye and come up with a mutually agreeable solution for both sides. And I after listening to this discussion, and I heard everyone's positioning, I actually am more convinced that we can come to a mutually agreeable solution, given what I understand to be the core quibbles that exist with the proponents and SCA 14. So that's my feeling. We're also going to hear, of course, about AB 844. There's this interesting hybrid initiative statute thing happening here, but you have to kind of look at both of them within the context of this negotiation that's ongoing. So with that, if there's any other comments from the committee, I'll entertain a motion for Senator Wolk's SCA 14. Okay, so there's a motion due past the Senate Appropriations Committee of SCA 14. I'm sorry? Yeah. Yes,
I'd like to just have a quick closing comment.
absolutely, please.
I didn't want to go through every intimate detail line by line, but
You can if you want to.
no, I don't want to, because we're going to go through it with AB 884. But I do think that it's important that somewhere along the line to point out the fact that SCA 14 only provides a portion of what CLTA provides, and that the rest of it would be statutory in an assembly bill that could easily be changed. And I think that when you're talking about protecting the public's right to know, it's very important that it is constitutional and not at the whim of today's legislators or tomorrow's legislators. It should go back to the people for a vote because it's their right to know. So thank you for accommodating me.
No, absolutely, Mr. Vice Chair. And I think ultimately that Dr. Munger and Senator Blakesley are acutely aware of their leverage in this situation, and I can only imagine that they would only sign on to an agreement that address the core transparency and right to know issues, values that you've just expressed. So that's my thoughts about this. So there's a motion made by Senator Liu.
Close, just a couple of comments.
Okay, the senator would like to close.
Yeah, given the comments, I just wanted to springboard off of what Senator Hancock said, and I just took a look at this. You know, again, you have two things before you. You'll have, after this, you'll have Assemblymember Gordon's measure that deals with the whole issue of recording and keeping records. What you have before you is a constitutional amendment, to get specific, and it's very short and sweet, and it basically puts in the Constitution the requirement of the 72-hour notice. It's not, and that's what it does. I am keenly sensitive to the fact that our Constitution is looking more like a regulation rule book with 473 amendments. I think it's way out to, at this point, 573, excuse me, something along those lines. I know it's in that range. But this is very limited and does put that portion in the Constitution. But I just think I can't stress enough how important it is. I think that this should be part of a negotiation, and I apologize to the proponents that this wasn't started a long time ago, but all I can tell you is, you know, I too have suffered the frustration, and what you've seen here before in terms of this committee is in the members of both parties of a willingness to engage at a level that we didn't used to see years ago. So with that, I'd certainly ask for your support on behalf of Senator Walsh.